Appeals Division 1 is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in Thomas versus Montelucia Villas, LLC, our cause number 1CA CV150489. Let's begin with introduction of counsel.
Your Honor, Franklin Jeans and Cassandra Ayers for Mr. and Mrs. Thomas.
Joel Sands and Phil Ortega, Fidel Shetway, here for Montelucia Villas.
Thank you very much. Thank you for joining us this afternoon. I'd like to go through a few preliminaries. Each side has 20 minutes. If the appellant would like to reserve some time for rebuttal, when you go to the lectern, if you'll let us know approximately how much time you'd like to reserve for rebuttal, we will do our best not to poach on it so that you will really end up with your rebuttal time. We are recording these proceedings today, both audio and video. The video will be on our website in a few days, and you can also go to YouTube and to view the video. But since we are also recording them in an audio fashion, when you go to the lectern, if you would please restate your name, so if a person's listening, they'll be able to identify the speaker. Let me also advise you that we have reviewed carefully the briefs. We're quite familiar with the history of this case. We have reviewed pertinent portions of the record. We're familiar with the issues and the arguments you have raised. We've also met and conferenced the case and discussed the issues you have raised on appeal. So with that said, let's go ahead and begin with counsel for the appellant.
Thank you, Your Honor. I'm Franklin Jeans. I represent Mr. and Mrs. Thomas, the appellants at this matter. I'd like to reserve 5 minutes of my time, and I'll try to be very circumspect in any case. We're here because the case has been, as this court knows, from the trial court to the appellate court to the Supreme Court to the trial court, and we just couldn't stand not coming back up here as well. At the trial court on the second time, the court was charged by the Supreme Court to consider on remand whether or not the defendant in the case, Montelucia, had the ability to close on the transaction on May the 16th, 2008, which had been submitted by the parties and acknowledged in the answer, the complaint, the answer, and throughout the proceedings as the acknowledged closing date, and without which there could not have really been a repudiation of the contract. At the trial court the second time, in fact, Montelucia diverted the court's attention from the real issue that had been remanded, and instead said that that there was the ability on their part, they had the right to delay the closing from May the 16th, 2008, or reset the closing, or not have a closing on May the 16th, 2008. They've said them all, and they did have until 9 January 2009 to close. The fact of the matter is that they couldn't raise that issue. And they said that they had the right to raise it because they had our consent, or the Thomas's consent, to try that issue because we did not object to the issue. And the fact of the matter is we did object because what we said to the court was this issue has been settled by the court throughout this process, by the admission of the parties, and by the record in the case and the rulings of the courts. We subsequently, when it came to this court, we briefed that issue, and we cited Schwartz v. Schwerin, where Justice Udall, way back when I was in high school, said that, in fact, if you admit something in your answer, it becomes binding on the parties, then it can only be changed by amendment of the pleadings.
Can I take you back, Mr. Jeans, because I actually think the stronger argument is law of the case, and the parties can't alter a mandate or a law of the case as decided by the appellate courts, can they?
You're absolutely right, Your Honor. I was going to get to that as we got down the road. The fact of the matter is, yes, the Supreme Court told us what to do.
Well, the Supreme Court, and let me walk you through my understanding, and I refer to them as Thomas 1, meaning the Court of Appeals decision, and Thomas 2, meaning the Supreme Court decision, just for clarity. the parts of Thomas 1 that this court decided on anticipatory repudiation, paragraphs 6 and 7, were specifically undisturbed by the Supreme Court. And it seems to me, if I were in your shoes, the strongest argument would be this precise quote from Thomas 1 that was undisturbed. At the time of the May 6th letter, Montelucia had not breached the purchase agreement. It still had until the May 16th, 2008 closing date to perform its obligations under the contract. Why do we even need to look at judicial admissions, estoppel, and those other things?
We don't, Your Honor. In fact, that's exactly correct. The reality is that the trial court did not honor the remand from the Supreme Court to define the issue, and the Supreme Court had agreed with this court that, in fact, there was an anticipatory repudiation because there had been a refusal to even close on, or to close. There's a 10-day period, May 6th to May the 16th. And in fact, that is exactly what we believe has happened here, is that that mandate and that remand were not honored, and this has to be sent back to that court for that purpose.
And the parties can't alter the mandate or the determinations that were undisturbed in Thomas 1. So let me jump to the next question, which is, as I understand Montelucia's alternative argument on appeal, let's assume that Judge Brain should have applied a May 16, 2008 closing date. They say, as a matter of law, we still win. Why is that not correct?
It's not correct because the evidence doesn't support that. It presents a triable issue of fact. It wasn't tried to that court.
What are the issues of fact as to Montelucia's ability to close as of May 16, 2008 from your perspective?
From our perspective, it is that when they sent their letter setting the closing date on April the 25th, they included a letter that they wanted the buyer to sign, addressed to the city, that, or to town of Paradise Valley. That letter said that they were waiving certain requirements of the contract. There was a provision. Remember, this is a $3 million house in a resort community. Some of what you buy when you buy a $3 million house in a hotel resort community is you buy the amenities of the resort. You would buy certain aspects that you would not normally get just with a standalone residential house. And those items were not, the building itself was completed, but the other issues were not addressed, including the amenities of the hotel. The hotel was not going to be complete. There was a condition from the city that the hotel had to be complete before they would give certificates of occupancy. And in fact, that hadn't happened, so the city asked for it to be waived. And in fact, when after the trial was over, they did did a deposition with the official of the town, and that official said, we would have given him a certificate of occupancy if we would have gotten the letter from the owner. The owner had, or the buyer. The buyer had no responsibility to sign that letter. It was an amendment of the contract. They raised the issue that there's a covenant of good faith and fair dealing in every contract, and we had a good faith obligation to sign that letter, but the fact of the matter is you can't use the covenant of good faith and fair dealing as a matter of law to amend a contract. And that's what they were asking for.
And is there a distinction between what the town of Paradise Valley was willing to waive, i.e. the conditions of the special use permit, and what the purchase contract provided would be in place before closing? Are they synonymous?
No, as a matter of fact, the city or the town wanted these various things waived. One of them, by the way, was the access. And there was a life safety issue with access. As you may know, this property fronts on Lincoln Drive. There was no deceleration drive. There was no deceleration lane there so that you could get off Lincoln Drive. And in fact, I talked to the client before that letter was sent, and he was concerned that his wife and he would get in an accident getting in and out of the property because of the lack of a deceleration and acceleration lanes. So there was a life safety issue as well. And that's part of what brought all this on.
And I guess what I'm looking at is I believe your client submitted an affidavit saying that basically signing the waiver letter would have deprived them of the benefit of the bargain. And so I'm trying to understand what factual issues, let's say hypothetically speaking, we agree Judge Brain had to apply the May 16, 2008 closing date. in your view, there are triable issues of fact about whether Montelucia could have complied with its obligations under the purchase contract as opposed to its obligations under the special use permit?
Actually, we don't, Your Honor. What we say is if you look at the evidence that was presented by Montelucia, you'll find that this requirement for the letter remains in place. And as long as that requirement waiving contract conditions remains in place, our client was not getting the benefit of the bargain that they had signed up for, that they were going to about to pay the balance of $3 million, $2,400,000 for, and they had a right to get that. So therefore, Montelucia, under any circumstances so far presented, didn't have the ability to close. Having said all that, if the court believes that it's a close call or that there is additional evidence needed, then it probably should be sent back for a full hearing.
It wasn't really tried. I mean,
It wasn't
Judge
tried.
Brain chose the other date, and so
That's correct.
nobody focused on the earlier time period specifically. Thank you. I know I got you off track, but I'm done for now.
Okay. Well, no, that off track is very important. What I wanted to do for the court's assistance here is on the consent issue. There are two cases that are not cited in our brief, or anybody else's brief for that matter. One of them is a case called Magma versus Industrial Commission of Arizona, 139 Arizona 38, 1983. It's a Supreme Court case, and in that case, the court says, and this is it's actually Justice Feldman, the court says, the admission of evidence relevant to an issue which has been expressly raised can be taken as raising a different issue which has been impliedly excluded by an express limitation of the issues to be heard. Amendment may be allowed when an issue, though not formally raised, has been tried by consent of the parties. However, permitting evidence relevant to an existing issue, close of escrow was an existing issue that was consented to by the parties, to be admitted without objection does not constitute implied consent to trial of an issue which has not been raised. I have a copy of this case if it would be of convenience to the court. I've provided a copy to opposing counsel. There's a parallel case called I'm gonna murder this. I hate to say it. It's called Bujanda versus Montgomery Ward. I call it the Montgomery Ward case because I can say that easier. And it goes to a similar type of issue.
Actually, just give us the site. We won't worry about it.
Okay. Let me just tell you what the site is. It's 125 Arizona 314. This case is a Division II case. And that case also goes to this issue of when can an implied consent and when is it prejudicial? And it says essentially that it is prejudicial if even if you went to amend it, it would be prejudicial at the end of the trial to allow an amendment under circumstances when it would change the theory of the case. It certainly here would change the theory of the case. This case went all the way to the Supremes on law not made yet in Arizona on the duties of the person who is the breachee in an anticipatory breach.
Counsel, treating those as akin to a supplemental citation of authorities, what page or paragraph of your briefs would that supplement an argument that was previously made?
Very good question, Your Honor.
Is that basically in reply to the answering brief's contention that, hey, you essentially allowed to be this issue to be retried or tried on remand?
That is what it is, Your Honor.
But again, if law of the case is the applicable doctrine that we rely on, we don't really need to go there, do we?
No, you don't. You're absolutely correct. Can I just say as an aside, the youngest member of our team, who's a young associate, 3-year associate, said to me this morning, isn't this the issue here? Nobody followed what the Supreme Court wanted them to do.
Why isn't that person arguing?
Yeah, I don't know. Well, I can tell you why. It happens to be my son-in-law. He's out finding out what baby he's getting today. So
Okay, well, we'll give you that
I
one.
appreciate that. At any rate, in the Magma case, it's on page 46 of the citation that I gave you, which was 139 Arizona 38. And in the Montgomery Ward case, it's on our, it is, sorry, I'm almost out of time here. I think, Your Honor, that it is at page 316. And with that, I will thank the court for your attention, and I answer any other questions you may subsequently have. Thank you.
May it please the court, Joel Sanis from Udall Shumway here with Phil Ortega as counsel for Montelucia Villas. It's a pleasure to be in front of this panel, and happy to be here on a matinee oral argument. Judge Downey, I'm going to go straight to the issue of what the remand was. First, obviously the Court of Appeals decision was vacated. It wasn't vacated in part, it was simply vacated. So I don't think we can look to the Court of Appeals decision.
We got to iron that one out, because I don't think that's correct. The Supreme Court specifically left intact paragraphs 6 and 7 of the Court of Appeals decision, saying that the Thomases had not appealed anticipatory repudiation. And so they say, we vacate the Court of Appeals opinion except paragraphs 6 and 7. So paragraphs 6 and 7 of this court's decision are clearly still the law of the case.
Well then, Your Honor, the remand says, and this is the specific language of the remand, this is from paragraph 17 of the Supreme Court's decision. On remand, I'm not going to quote the entire paragraph, I'm going to quote what I think is the pertinent language. On remand, Montelucia bears the burden of showing it was able to close in accordance with the contract. If it is ultimately determined that Montelucia was ready, willing, and able to perform as required by the contract, the court can determine the appropriate remedy. The Supreme Court had the ability to say, close by...
Inconsistent, because paragraphs, as I read when Mr. Jeans was arguing, paragraph 6 of this court's decision, which was left intact, specifically said that the question, now I have to find it again. So I think you have to adopt this language from the Court of Appeals decision. At the time of the May 6th letter, Montelucia had not breached the purchase agreement. It still had until the May 16, 2008 closing date to perform its obligations under the contract. So the Supreme Court's statement that, yeah, trial court, go back and determine whether it could perform its obligations under the contract, absolutely had to include the paragraphs that it had kept intact from Thomas 1.
My only response to that, Your Honor, would be that the Supreme Court had the ability to say, perform by May 16, 2008, and it said perform in accordance with the terms of the contract. And I think
Suppose, then, the Supreme Court specifically left intact those two paragraphs of our opinion. If they vacated the whole thing, I completely understand your argument. And then we only have what Judge Downey has referred to as Thomas 2 to look at, but it didn't.
I think the reason is, and we had anticipated this, is that the Supreme Court had this as its issue on review. The Supreme Court said, we granted review to address whether a defendant must prove ability to perform or retain damages for anticipatory repudiation, which they said was an issue of statewide importance, but at that time it hadn't been decided by any court in the entire country, and it was an interesting issue. When a party is anticipatorily repudiated and the non-repudiating party claims breach of contract and tries to collect liquidated damages, can they collect liquidated damages if they haven't been damaged by the breach of contract? So, if they and the Supreme Court said you must prove that you've been damaged by the breach of contract by proving that the non-repudiating party was ready, willing, and able to perform. So what the Supreme Court did is it created an entire new landscape, legal scape, in other words, for how this case would have been presented. So then the question then becomes, should Montelucia have had to go back to trial court under the entirely new legal landscape? Remember, at trial court, we argued, Judge Suma, that anticipatory repudiation means they breached the contract, were entitled to take the earnest money. Montelucia is entitled to take the earnest money. If there was never any question at that time that Montelucia would have to prove it was ready, willing, and able to perform. So the issue of the closing date, when the closing date wasn't a germane issue at the point. It was, did the anticipatory repudiation occur before Montelucia ever had a duty to perform? And it did. So then we go back to the trial court into this new legal landscape, and now we have to look at what the contract provides under the closing date. And that's where we get into the next. The decision says, first of all, was the May 18th decision an issue decided in the first decision? That's the Lennar Corporation Homes case that we cited. May 18th wasn't relevant. The only thing was relevant was there anticipatory repudiation? That's what the Supreme Court decided. One, was there anticipatory repudiation? Judge Downey's pointed out the Supreme Court said there was and affirmed the Court of Appeals decision. Then two, what are the consequences? Well, Montelucia has to prove it was ready, willing, and able to perform. So those are the issues that were decided. Those are the only issues that were decided. None of those issues say May 18th was the important issue.
Tell me about the procedural context of Lennar.
That I don't know, Your Honor. I'm sorry.
Isn't law of the case sort of hypersensitive to procedural contexts of the cases? And let me give you a hypothetical. If the Supreme Court remands a case to Superior Court with directions to dismiss, and a plaintiff comes in and says, but Judge, we have different evidence, is the Superior Court not bound by the mandate directing that the case be dismissed? It's not this case. It's not this case, and I'm not suggesting it is. But if and the same, I think, would obtain if this court said that, or if this court said that and the Supreme Court left intact that portion of our opinion. So I guess I struggle somewhat with the thought that the Superior Court here had the ability to sort of say, well, sure, this has been through two appeals, appeal and a petition for review, and at one point, a chunk of the Court of Appeals decision, the Supreme Court expressly left intact, said May 16, 2008 is the magic date. But I really don't have to follow that. Isn't that one way to look at this case? I'm not saying you agree with that way, but isn't that one way of doing that?
Is that a way? I think that is a way of looking at the case, yes. Yes.
And that, it strikes me, jurisprudentially, the Superior Court didn't have the authority to do under law of the case.
Well, it depends on what issue was decided. And
why is it that it depends on the issue that was decided as opposed to what the appellate court, here the Supreme Court, says?
Well, because the law of the case doctrine only applies to an issue that was decided.
If you're looking from one Superior Court judge to the next, I completely agree. But I don't think a trial court can pick and choose which portion of an opinion that, and let's use a stronger example, that the Supreme Court issues with respect to facts or other things.
I'm trying to communicate a difference in perspective here. I don't believe a trial court has the ability to say, I'm going to decide something differently than what the Supreme Court or Court of Appeals has decided. What Judge Brain did is say the Court of Appeals and Supreme Court did not decide that May 16, 2008 was the closing date.
You know, Mr. Sands, I have the Court of Appeals decision right in front of me, and I'm looking at paragraph 7, and it says, at the time of the May 6th letter, Montelucia had not breached the purchase agreement. It still had until May 16, 2008 closing date to perform its obligations under the contract. The time for Montelucia's performance had not yet arisen. That is the paragraph that the Supreme Court carved out and maintained in the Court of Appeals decision. I cannot see how there is any wiggle room on May 16, 2008 as the date of the close, given that explicit language in the Supreme Court's carving out or saving that particular paragraph of our decision.
Then I'll give you the wiggle room.
Okay, give me your wiggle room.
The wiggle room is in the Dancing Sunshine's lounge case that we cite that said that if application of the law of the case would result in a manifestly unjust decision, and we looked up other decisions of the court, the unpublished decisions, both Judge Downey and Judge Suma both agreed with this. Judge Downey in the Freenel case, which was CACV 11-0179, Judge Thuma in the Wooten v. Bear case, CV 150453, both said that when there is a change in the facts or change in the law, then it would be unjust to apply law of the case. And that's where I go back to what happened at the trial court.
Okay, stop for a second.
Yes, Judge.
They may agree with you, but you haven't persuaded me. I haven't written on this
I
yet.
apparently agreed in that case.
Okay,
But let me tell you that the manifest injustice, I have a hard time seeing how that would run in favor of Montelucia, because Montelucia in the trial court before the appeals took the position in various documents. I mean, I told Mr. Jean's judicial estoppel wasn't my favorite of his arguments, but your client repeatedly called the May 16th date of closing. In fact, your counterclaim sought a, quote, late closing fee of $1,000 per day from May 16th, 2008 until closing occurs. And the anticipatory repudiation by the Thomases was based on that May 16th date. So it seems to me the manifest of injustice would run in their favor, that if we didn't apply law of the case, it would be manifestly unjust to hold them to have repudiated based on that date, but you're free to apply a much later date.
Well, you won't be surprised that I disagree. And the reason why we disagree, Your Honor, is because the legal landscape at the time was the party who anticipatorily repudiates must sacrifice their earnest money. That was all that we had to prove at the trial court level and in front of the Court of Appeals, is that the Thomases anticipatorily repudiated.
But here's the problem that I see. Maybe that was one way of saying that was a narrow issue. But this case was pled, argued, briefed in the trial court, in this court, and in the Supreme Court based on the acceptance that May 16th was the closing date. And so that's how everything was positioned and phrased. Then, when there is a dispute about whether you're ready, willing, and able by that date, the parties had locked that date in. It's as if you'd gone around the Kentucky Derby and you'd crossed the finish line, and everyone has been riding that horse. Well, that horse has gone around, and has gone around the first time, the second time, and the third time. And I don't see, as Judge Downey was saying, any manifest unjustness in making you stay on the horse you rode.
Well, the manifest unjustness, if we would have known that the Supreme Court was going to rule that a party must prove it's ready, willing, and able to perform after an anticipatory repudiation, then we would have made the arguments that we're making now, and that is that the contract closing date, and that's all this says. If we're talking about the closing date, it's the closing date. There's a difference between a contract closing date and a deadline to perform. We didn't know we had to prove what our deadline to perform was until the Supreme Court said we had to prove we're ready, willing, and able to perform according to the terms of the contract. So that is manifestly unjust to say that we're under a completely different legal landscape. We did not know we had to prove readiness, willingness, and ability to perform when we were in front of Judge Gamma in 2010. The Court of Appeals agreed with us that we didn't have to prove readiness, willingness, and ability to perform. The Supreme Court, in a sui generis case, not decided in Arizona, not decided anywhere in the entire country, said we have to prove readiness, willingness, and ability to perform. So the law changes, poof, in front of our eyes. So we go back to court and we say, well, let's look at what the contract is. Contract closing date is one thing. Contract deadline is another. And we have a contract that says if we give you a closing date and it's not the deadline, you have no right to rely on that closing date.
But then their alleged breach should go proof, because your client alleged that their refusal to go forward with the closing on May 16th constituted an anticipatory repudiation. So you can't have it both ways. You can't say they're bound by that date, we're not.
Well, then let's go back to court and ask if they're bound by that date and see what the effect of this language is in their closing, in their letter. Because in their letter said, Mr. and Mrs. Thomas will not close the transaction on May 16, 2008, and instead hereby notify you that they are canceling the agreement and demand a full refund. That's an anticipatory repudiation. And remember, there was an opportunity to cure here. So they also denied us the opportunity to cure. So it's not unfair to them to say, you canceled the contract. You didn't even give the opportunity to cure under the contract. So we have a right to look to the contract and say what our contract rights and remedies were. And we had a right to continue the closing deadline. They had no right to rely on any statement which is a closing deadline. So when they say, well, we relied on May 16, 2008 as a closing deadline, so we terminated, they had no right to rely on it. There's a contract that says they don't have a right to rely on it.
Well, if we just had the contract to work with, I understand your argument, but we don't. We have Thomas 1 and we have Thomas 2. And at least from my reading of Thomas 1, and I was not on that panel as I recall, it makes it pretty plain that there's some magic in the May 16, 2008 date. Now, I understand the arguments you're making today and the arguments you made to the Superior Court. And had you told the Supreme Court, look, let us go litigate this, don't bind us by this date, we might have a different case, but that's not the case we have today.
Well, it doesn't sound like I'm going to be able to persuade the panel on this issue, except the other point I would make on that is we really don't have an opportunity in front of the Court of Appeals or Supreme Court to say don't bind us to that date. We have to go with the record that we have. And so I'm just going to repeat that we had a complete change in the legal landscape that forced us to prove we're ready, willing, and able to perform, which justifies us in avoiding the law of the case doctrine. And I don't think I can get any better on that.
Well, and I understand that, but to me, it's looking carefully at the language of those decisions. And had the Supreme Court done one or maybe two things, one is vacate entirely what we've called Thomas 1, different case.
Mm-hmm.
Or if there'd been a request, for them to do that after they issued their decision, or if they said, look, we use these dates as approximations and we understand there were no findings and this is a new legal concept, but that's really not what happened.
I feel like I've made all my points on this. I do want to go on to the alternative argument that we were ready, willing, and able to perform by May 16, 2008. And what I want the court to look at is the language that we have in footnote 2. We had Robert Lee in deposition, and this is footnote 2
Your brief?
of our brief, okay. Yes. And it cites of our responding brief, our answering brief.
Yeah, I'm
yes.
sorry, the answer brief. Yeah.
Footnote 2 on page 4. And we quote to the record from the deposition of Robert Lee. He was the inspector in charge of this project. And what Mr. Lee said is that the Town of Paradise Valley had an agreement with the State Department of Real Estate not to issue any certificates of occupancy until the special use permit had been complied with. So it wasn't just the Town of Paradise Valley making that decision. They had an agreement with the State Department of Real Estate.
And you're running out of time. Let me just jump to the question I asked Mr. Jeans on this point, because I understand where you're going. And Mr. Lee testified they wouldn't have issued the certificates of occupancy unless the infrastructure and the amenities required under the special use permit were completed. So my question to Mr. Jeans, which I'll also ask of you, is, so let's assume that means the special use permit requirements had been satisfied, but does that necessarily mean that all of the conditions set forth in your client's and Thomas's purchase contract had been satisfied? I don't think that Mr. Lee was opining as to
that. I can say absolutely to that question because, and we cite this in our brief, the condition for completion of the home is a certificate of occupancy by the Town of Paradise Valley.
Well, no, it's quite more than that. It was escrow will not close until the town issues the occupancy, and the villa's infrastructure and villa's amenities have been completed in addition, and there are other things. But so my question was, do we know that special use permit amenities and infrastructure are exactly the same, synonymous with the language in the purchase contract? And Mr. Lee can't tell us that. So I was looking for what in the record would tell us they're one and the same.
There was nothing in the record except that they're one and the same. There's no other definition of amenities, privileges, and access.
And that's a problem in the purchase contract, I think, is those things aren't defined. And I saw there was some quibbling at some point about what was exactly the scope of the amenities and the infrastructure. And so in my mind, that creates a factual issue on that point. The contract defined, I don't have the record citation because I wasn't this deep into that particular issue, but the contract does define the obligation. Well, the contract says that the obligation to close
that language that you have in front of you, Your Honor, says that is once the town of Paradise Valley issues a certificate of occupancy, Montelucia has satisfied all of its obligations to close. That's the bottom of that paragraph.
Really not what it says. Buyer acknowledges that escrow will not close until the town of Paradise Valley has issued an occupancy clearance and the villa's infrastructure, quote, in quotes, and, quote, villa's amenities, which are not defined in the purchase contract, have been completed. And so that's the factual gap I see here. Sure, Mr. Lee can say the special use permit requirements were satisfied, and that absolutely works in your favor on that point. But do we know that that means the exact same thing as these parties meant by these undefined terms in the purchase contract? And you all argued over that in some context in the Superior Court, somebody saying, oh, it included certain resort amenities, and the other side, no, it didn't. And so I'm not finding Mr. Lee gets you all the way home on that point. He gets you part way.
Judge, that's the interplay between Section 4 and Section 8, which we discussed. Section 4 referred to decisions of the town of Paradise Valley would make regarding completion of villa infrastructure and villa amenities. So it says, Section 4 says the town of Paradise Valley would decide when those are complete. Section 8 of the contract then refers specifically back to Section 4 and recited the town's final inspection and acceptance of the home would satisfy Section 4. The town's final inspection and acceptance of the home would satisfy Section 4, and said final inspection approval would, and this is from Section 4, confirm that the obligation of the seller had been fully satisfied and discharged. That's the language I was looking for. So look to Section 4. If we get it,
then it goes on about, in addition, occupancy clearance will not be issued. That's not,
Judge, it says, Section 4 says, the final inspection approval would confirm that the obligation of the seller has been fully satisfied and discharged. And so now we know that we had a certificate of occupancy on May 16, 2008. We showed you the screen print that said it. Robert Lee said it.
well, that was still, at that point, that they were still requiring waiver letters.
The waiver had been, for one owner had been waived previous to that. That's Unit 23.
And that's a fact in your favor, but it doesn't show as a matter of law that they would have done it as to the Thomas's property, does it? You're out of time, so I'll let Judge Norris decide how we go.
Why don't we finish that conversation? Go ahead and finish the
I
response.
don't think I have much more to add to that conversation, Judge Downey. The contract to me says what it says, that when there's a final inspection and a certificate of occupancy issued, which we know happened, we had a certificate of occupancy from the screenshot saying a certificate of occupancy can issue. They wanted a waiver letter.
Well, we know it didn't issue until August 27, 2008.
No, we had final inspection and completion of the home. Final and inspection and completion of the home, which is what Section 4 requires. So final inspection and completion of the home, it's right in the screenshot. Final inspection and completion of the home was ready. That says ready for SUP. That's the special use permit. So we have the certificate of occupancy issuing as of May 16, 2008. But then they said they want the letter, and the letter doesn't have anything to do with the certificate of occupancy, final inspection and completion of the home.
Would you like to make one or two sentences in wrap-up, or are you finished?
I am finished, and I really appreciate your time. Thanks very much.
Very much. Mr. Jeans, you have about 6 minutes and 30 seconds, and if you need,
I'm not going to take 6 minutes and 30 seconds.
but if you need a few more seconds,
I
we'd be
will.
glad to accommodate you so that you don't feel like
We'll keep
we
this
played
very
unfair.
brief. I think the court has. Oh, I've got to go to the microphone. I'm still in the day of yelling, but anyway, Your Honor, your questions concerning the opinion of the Supreme are spot on. The Supreme Court decision, in fact, says on April 25th, this is paragraph 3, on April 25th, 2008, Montelucia notified the Thomases by letter that it had set the closing date as of May the 16th. I don't think they could get much more clear on that. It went on then to render what had happened with the Court of Appeals in the next paragraph. The Thomases responded May 6th that they would not close on May 16th, and that was a repudiation. Without that, we wouldn't have had a repudiation. The only other thing I want to say is Mr. Sandus has said on several occasions that this was a novel decision by the Supreme Court of Arizona. I practice in Arizona, Nevada, and California in this area. We are the only state that didn't have that rule at that time, and did not think that that would be eventually the rule. It would be kind of surprising, since it seems to be the majority rule nationwide. Lastly, and I think most importantly, is this issue of what was required to close. The fact of the matter is, if you read their rendition of the town's director of construction, Mr. Lee's testimony, he says at the end, they go through what would have to be done to get a closing, and they say, and then the only other requirement would be need letter from owner. Is that right? Yes, sir. Still need the letter from the owner. And that letter waives rights that were protected in the contract. And in fact, one of the things that had to be completed here was that the hotel had to either be completed or had to be refinanced from the construction loan, apparently. And that hadn't happened. So this was an uncompleted project. They were trying to raise funds to complete the project, a meritorious idea, but not by completing the project. And without the completed project, our client would not have got the benefit of his bargain. And with that, I thank you. I'm happy to answer any other questions the court may have.
Well, thank you very much.
Thank you.
We appreciate the time you spent preparing today and your participation in argument. We'll take this matter under advisement and issue a decision in due course. Thank you.